issues in respect of claiming refund under section 54 at the time of export of goods without payment of tax. The first issue that has been raised in the petition by the petitioner was the timeline that is applicable for unutilized ITC on account of export of goods without payment of tax. And the second issue that has been raised is whether the amendment made in explanation to E is retrospective or prospective. So these two issues has been raised by the petitioner. The statutory scheme of section 54 in respect of claiming refund for export of goods without payment of tax broadly deals with the two situations. The first one is payment export of goods without payment of tax, and the second one is refund of unutilized ITC. That means the export of goods without payment of tax, and in the case of refund, in case of inverted duty structure, that is when your output tax rate is lesser than your inward tax rate. So these two situations are deal in the case of export of goods. So the first issue that has been raised before Delhi High Court, that is the timeline which is applicable for unutilized ITC. Department said the explanation 2A is applicable for unutilized ITC and not explanation 2E. Now what is 2A and 2E is all about? First one, for claiming refund, the timeline under section 54 is given is 2 years from the relevant date. Now what is relevant date? It has been explained through explanation under section 54 under the different scenarios. So for this particular situation, that is for export of goods without payment of tax, that has been dealt by under the act under section 54 in explanation 2E. But department has said for the export of goods, explanation 2A is applicable, which is relating to export of goods. But 2A is for export of goods with payment of tax, and 2E is for export of goods without payment of tax, that is unutilized ITC on account of zero rated supply or unutilized ITC in the case of inverted duty structure. Delhi High Court clearly says that if there is a specific explanation has been given under the Act for unutilized ITC, then only the specific explanation will be applicable and not general clause which is for export of goods, and explanation 2A is not applicable, explanation 2E is applicable. So first issue that has been dealt by the Delhi High Court. For the second issue, now 2E is applicable for export of goods without payment of tax. But for the second issue, there is a amendment made in 2E on 1st of February 2019, that the relevant date for calculation of 2 years from the relevant date is before the amendment 2E was at the end of the financial year. That means if the refund claim is for financial year 2017-18, then the ACC can claim the refund till 31st of March 20. That was the timeline before amendment in 2E. But with effect from 1st of February 2019, the timeline has been changed, and that has been changed as the refund can be claimed on at the end of the due date of filing of written under section 39. But in the petition, petitioner was claiming refund for the period 2017-18, and the department was saying there is an amendment in first in explanation 2E for claiming refund, and that is retrospective effect, that is first not from 1st of February 2019 but retrospective when the GST has came into effect. Delhi High Court came to the conclusion for this issue, concluding that the amendment section cannot operate retrospectively so as to take away a vested right. It is a vested right of the petitioner that he can claim the refund if the prospective effect can be given to the for claiming refund, there will be the takeaway of the vested right of the appellant. So that is the reason the amendment provision will not be applicable retrospective, it will be prospective. So these issues has been dealt in this